as I think Justice Rastogi put it in the right perspective, that the institution of the advocate on record is really the backbone of the court. And it is one that I think sometimes is taken for... It's okay. Closer. We are all used to saying, am I audible? It's an institution that I think sometimes we underestimate and overlook. Occasionally you have calls that why do we need advocates on record? But it's an important part of the court and the functioning of the court. And I just wanted to deal with some aspects of what I perceive as the duties of the advocate on record in particular, and then some general instances of professional ethics that have come up before the court. There is, I think, before the lecture, one of the executive members shared a very exhaustive list of case law with me. That's a very good list. Please contact them for, it'll, I think, assist you a great deal in your preparation. But I've taken 2 or 3 subjects out of that. It's not possible to cover everything in a short talk. I would like to concentrate first on the few cases that have arisen directly concerning advocates on record, because the professional ethics and the expectations of the profession, as you're all aware, is broadly covered in the rules of ethics prescribed by the Bar Council of India, framed under Section 49 of the Advocates Act. There's duties to court, duties to your opponent, duties to your client, etc. And those, of course, are general rules. They're pervasive. They apply to all sections of the bar, irrespective of which court you practice in. But there have been some interesting episodes or instances that have taken place in this court, and I think those are also important to understand as to what is not only your role as an advocate, but as an advocate on record in particular. So I'll just deal with 4 or 5 of those occasions that have arisen. One was advertising or solicitation. Now, in the current scenario where we have social media, Instagram, internet, websites, it seems very commonplace for us to be able to advertise our services. But there was an interesting case in 1962 where a person became an advocate on record. And he wrote a postcard to, I think it was the Law Secretary of Maharashtra, saying that I have become an advocate on record. No doubt you must be having an advocate on record, but I'm offering my services to you. Now that somehow reached the attention of the court. It was brought to the notice of the court, and the court took a very strict view of it. And the court said, the Constitution bench judgment, said that the lawyer lacked moral fiber and ought not to have solicited work like this. Now that may seem a little strong to us in this day and age, and for that misdemeanor, the person was suspended as an advocate on record for 5 years. So that's the, if I may say so, the high standard that the court expects from an advocate on record. This may be an instance of solicitation or advertising, but as a general, in my feeling, that it's an indication of the importance that the court bestows on what is the role of the advocate on record and what the court expects an advocate on record to be. An advocate on record is not just someone who has the ability or the authority to sign that wakalatnama and file petitions. The advocate on record has a greater responsibility. Which brings me to the second aspect, which is very common, and the court has commented more than once, which is name lending. Because that's a very common practice. You have instances where people file endless number of petitions for other advocates without knowing what is the content of the petition, whether they have read the petition, they may not even appear in the petition. And there was one instance, I don't want to take the names because they're also, they're reported judgments, where the court found that the particular gentleman had filed in 2 years 1,300, 1,400 SLPs. And it was found that that is just not physically or feasible for one person to have had that quantity of filing. So though the person apologized, the advocate on record concerned apologized, but the court did strike a note of caution and said that name lending is not something that is something to be frowned upon. There was another round of this litigation in 2014 the court gave notice to the Advocate on Records Association, and at that stage the court said that we have now been apprised that this issue of name lending is before the Rules Committee, and we leave it at that because the various suggestions given by the AOR association were taken note of. And that, you find, is now reflected in the new Supreme Court rules of 2013 in Order 4 Rule 10, which prescribes certain instances in which the court can, if they find that the conduct of an advocate on record has been unbecoming or lacks professional probity, the advocate on record can be suspended or prevented from acting as an advocate on record for a given period of time. And that actually happened in one case in 2017, if I'm not mistaken. The allegation against the advocate on record was that he had made an allegation against the registry about non-listing of a matter and certain practices in the listing of a matter, and had a grievance. So that was taken up by the court, and the court frowned upon it, and they said the advocate on record is not the mouthpiece of the client. There is some element of discretion, some element of restraint. You have to be able to filter what you say to the court and what you don't say to the court. You just don't come and let loose to the court and say, my matter is not being listed, I don't know, somebody is behind this, etc., etc. And in that particular case, the advocate on record was suspended from practice as an advocate on record for 1 month. The other instance is about, in terms of your duty to the court, is pleadings. Now we all know there is a whole body of case law that says that if a deponent makes scandalous pleadings, scurrilous pleadings, the deponent is liable for contempt. But what about the duty of the advocate on record who files it? Because is there not some element or degree of scrutiny that the advocate himself or herself must undertake before something is filed in court? Because it comes back to the basic assumption, are you just a person signing a paper because the rules permit you, you're the only authorized person to file pleadings in the Supreme Court, or is it a greater responsibility than that? And this happened in a case in 1995, where it was when liberalization of media had just started. This is the famous case of Cricket Association of Bengal and the Airwaves case. And a deponent, an officer of the Ministry of Information and Broadcasting, filed an affidavit saying, to the effect generally, that this court has passed orders not being mindful of the sovereignty of the country, etc., and cast some kind of insinuations on the orders that had been passed by the Supreme Court. The court not only issued notice for contempt to the deponent, but notice was also issued to the advocate on record to explain how such an affidavit came to be filed. Of course, certain extenuating circumstances were there. The advocate on record was in a position to explain that what had been filed was not filed with his knowledge and with his consent. So though the advocate on, no action was taken against the advocate on record, but the court did sound a note of caution, said this casual approach was deprecated, and there is therefore a duty on the advocate on record to make sure that what is filed in court, you just don't blindly file whatever your client gives you and say, sir, this is my point, you please file it irrespective of what you think the point is. You have a duty to the court and to maintain that standard, that you are not a mouthpiece of your client, and irrespective of what the client says, that has to be, if I may say so, literally dumped on the court. That is one aspect as far as I was able to discern few instances which are particular to advocates on record, and given their importance in the whole scheme of the functioning of the Supreme Court. There's another aspect that I thought I will touch upon, which is on a general aspect of professional ethics and the jurisdiction of the court and professional conduct. Now, as you're aware, this discussion invariably starts with the celebrated SCBA case and the case of VC Mishra, and what is the power of the court under Article 142, whether it can take disciplinary proceedings against an advocate who's errant or who misbehaves in the court. But there is another facet of this discussion which flows from Section 34 of the Advocates Act. Now, under Section 34 of the Advocates Act, there is a power for the High Court to frame rules, and frame rules regulating the appearance of advocates before it. This is very similar when you see various rules that have been made by some of the high courts. This is very similar to what our current Order 4 Rule 10 is. In fact, in one of the judgments that has been cited as a parallel. And there are 3-4 instances where this has come up. So the most common example is that certain high courts, like High Court of Kerala, there have been 2 cases, which made a rule under Section 34 that if an advocate is convicted of contempt, he can be debarred from appearing. Now that was challenged once by an advocate and the second time by the Bar Council itself, and twice upheld by this court, saying that as far as regulating appearance, as far as regulating appearance before the court is concerned, or the right to conduct cases before court, that power will still remain with the court. And that does not impinge with the power of the Bar Council to have its own disciplinary proceedings, etc. We then have, which all of you must be familiar with, the famous case in R.K. Anand's case, which was the BMW hit and run. Of course, there were certain actions taken against them in that case because the court found that their conduct was not becoming of lawyers. But in that judgment, there was one important observation which you will find in paragraph 238 of the SCC. That the court said that it is high time now that rules were framed in this regard by various high courts in exercise of powers under Section 34 to regulate in certain instances the appearance of lawyers, and in the judgment the court gives 3-4 instances: if you are faking documents, if you are taking money in the name of the judge, if you are tampering with the record, etc. Now, and a direction was issued that such rules must be framed. Now, pursuant to that those observations of that direction in R.K. Anand's case, the Madras High Court framed certain rules, and it sought to incorporate some of the instances and the examples given in R.K. Anand's case as instances in which a judge, if in a particular case, in a matter before that judge, it is found that a lawyer is guilty of one of those actions, then the judge could debar that person from appearing in court. That was challenged in an Article 32 petition before this court. And in Muthu Krishnan's case, the Supreme Court said that this would be an impingement on the power of the Bar Council, and therefore the rules were struck down. So, though the rules ostensibly were made pursuant to the observations passed by the Supreme Court in R.K. Anand, but the court found, or court felt, that this would be an excess of the powers under Section 34. However, the court did say that in case there is an instance where a lawyer misbehaves in some of those given instances, the court's power under the contempt jurisdiction gets retained. So it is not as if a lawyer may misbehave and get away with it, thinking that there is some technical statutory argument to be made that under Rule 34 such a power doesn't exist and you cannot take any disciplinary action. But the court retained the power or recognized that the power of the court to punish for contempt, that is always available. And so lawyers should not think that it is a situation where they can go scot-free. In fact, pursuant to, as a follow-up of that, there have been, in fact, there is a Law Commission report, the 266th Law Commission report on this aspect. But I think like most Law Commission reports, nothing much happened after that. But the judgment does note that this was one of the developments in the matter. The last part that I want to talk about is strikes, because now strikes, you have seen off late, have again become prominent. We've had some episodes in Madhya Pradesh, etc. Again, the strike jurisprudence has been there for a long time. Right from Harish Uppal, Constitution Bench has said strikes are illegal. There is no justification for a strike. you can't give any excuse that, just because I don't like the particular judicial officer, I want to abstain from work. So as a follow-up of that, there have been 2 or 3 developments. One is that, and it was mentioned in Harish Uppal itself, that you should now look at setting up a grievance redressal commission, or committee rather. At one stage, the court had asked the Ministry of Law to compile data and find out, what is the loss that has actually been caused to the system on accounts of lawyer strikes. I don't know whether that eventually fructified. But most recently, on 20th of April 2023, Justice Shah has passed an order in the case of the District Bar Association Dehradun, directing that there should be grievance redressal committees now set up, and the scope of the grievance redressal committee should be to look at grievances regarding filing, listing, etc. Or if you have grievances against a particular judicial officer in the lower judiciary, then those should be dealt with by the grievance redressal committee, rather than resorting to the extreme step of going on strike, which the court anyway has held right from, I think Harish Uppal is 2003, that is not permissible, and there is no justification, because that interferes with the administration of justice. The litigant is the sufferer, and that is not really, your job as a lawyer is to assist the court and not prevent the administration of justice. So these were some of the general areas that I thought I would cover today. As I said, they have prepared a very fairly exhaustive list which covers a lot more of the aspects regarding the Bar Council of India ethics, various decided cases. I think you should take it from them. That's quite a useful list. In fact, I use some of that for today's talk. And if there are any questions, I'm happy to take them.